Welcome. We're back. This is our second video. Now we're going to talk about subject matter jurisdiction. I'm going to give this one more time since this was early in the semester. Keep in mind that we'll be talking about a bunch of stuff today, but our time is limited. Just because I don't say something doesn't mean it won't be covered on the exam, and just because I say something doesn't mean that it will. With that in mind, let's turn first to Article 3 versus 1332 diversity. First, the scope of Article 3 is broader than the diversity statute 1332. Here's Article 3, Section 2, provides constitutional power for the courts for suits between citizens of different states and between foreigners and citizens of a state, respectively what we now call diversity jurisdiction and alienage jurisdiction. Keep in mind that there's two ways the Constitution is significantly broader than the diversity statute in 1332A. First is there's no amount of controversy in Article 3. Amount of controversy is a statutory requirement. Second, the Constitution would permit minimal diversity. So for example, if you had Pennsylvania versus Florida and Pennsylvania, that would be fine because there's minimal diversity between the plaintiffs and defendants. The complete diversity rule, which requires all plaintiffs to be completely diverse from any opposing defendants, that's a creation of the courts when analyzing and interpreting the statute. So complete diversity is not required by the Constitution, but rather by Section 1332. Well, let's turn to 1332 and start digging our teeth into it. Now first, we're going to talk about what does it mean to be a citizen of a state. You may remember this handout from way back when. There we go. We know that the diversity statute under 1332A1 requires first a lawsuit between citizens of different states, and second, an amount of controversy that exceeds $75,000, not counting interest or costs. Right now, let's talk about what does it mean to be a citizen of a state. That means to be, first, a U.S. citizen, the second, who's domiciled in a state. If either one of these is missing, then that person is not a citizen of a state. So if somebody is a foreigner who's domiciled in a state, they are not a citizen of a state. They're a foreigner. Even if it's a foreigner who's domiciled in the state, who's a lawful permanent resident, that person is still a foreigner. They are not a U.S. citizen. Let's expand upon this. U.S. citizen domiciled in the state is an incomplete analysis, right? Because to be domiciled in the state, you have to reside in the state and have the intent. That's either to stay for the time at least, to stay indefinitely, or to stay permanently. Courts vary on their approaches. That should tell you something very important. If you have an essay and you must analyze domicile, look very carefully in the call of the question or in the instructions to see, do the instructions tell you to use the majority approach, or are the instructions silent on which approach to use? If the instructions tell you to use the majority approach, then use the indefinite intent approach, the one from the Gordon case that we studied in the very first week of school. If the instructions are silent, then you may have to analyze the alternative. All right. U.S. citizen, domicile. Domicile means reside in the state with the requisite intent. And then for the requisite intent, there's three separate approaches. Okay. When we measure citizenship, what is the proper timing? Do we measure citizenship at the time the cause of action arose, the time the complaint is filed, or the time of trial? Time you file, that's right. What matters is the time of filing. This slide, of course, just fleshes out what I just said. Domicile is reside in state, requisite intent. And that second requirement has three approaches. And another way of looking at it is like this. Now, you'll remember we did this in the very first week or two of class. This is a model on how to structure the issue of citizen of a state, right? You'd have to address all these things just to determine whether a particular individual is a citizen of a particular state. And again, just to remind you, what if you have Nathenson, born in the in the U.S., citizen of the United States, and he moves to France. Is he a citizen of a state?
No.
He is stateless. He cannot sue, nor can he be sued under diversity. If he wants to be in federal court, it's got to be a federal question. Okay? Let's see. Let's look at the statute for a minute. Let's talk about this, the alienage statute. Alienage statute, 1332A2, requires that you have on one side a citizen of a state and on the other side a foreigner, somebody who is not a citizen of a state, who's not a U.S. citizen. Put differently, to be a foreigner, you have to be someone who's not a U.S. citizen. Suppose Bob is from Czechoslovakia. He's Czech. Is he a citizen of a state? No. What if he moves to Pittsburgh, PA? Does he become a citizen of a state now? No, he's still Czech. What if he becomes a lawful permanent resident who lives in Pittsburgh, Pennsylvania? Is he a citizen of a state now?
No.
He is not. So let's be very clear about how to analyze alienage jurisdiction under Section A2. This is the threshold thing that must be met. If this highlighted condition isn't met, then there's no alienage jurisdiction under A2, which requires first a citizen of a state. It could be plaintiff or defendant, doesn't matter, which uses the analysis we covered in the handout, the visual from a few moments ago. Then the other person needs to be an alien. Okay? We don't care where they live, we care that they're not a U.S. citizen. All right? If you have that, then the first condition is met. Then what about the language after the comma? Well, the language before the comma is a grant of alienage jurisdiction, and everything after the comma divests alienage jurisdiction. And it tells us that even when the first clause is met, we will divest that grant of jurisdiction if the alien is a lawful permanent resident who lives in the same state, who's domiciled in the same state as an opposing party. So, for example, suppose you have plaintiff who's a U.S. citizen domiciled in Florida versus defendant who's from France, so alien, who's a lawful permanent resident who's domiciled in Florida. Well, under the first clause, what you have is a citizen of a state, and you have a citizen of a foreign state. The first clause grants jurisdiction because it's a citizen of a state versus a foreigner. However, the except clause would divest that jurisdiction because the foreigner is a lawful permanent resident who's domiciled in the same state. And the policy behind that is, even though the second person is not a citizen of the state, there's no need for a federal form under diversity. This person is on their way to becoming a citizen and is domiciled in the same state as an opposing party. So the statute prevents there from being alienage jurisdiction. Now, if I took out one of these conditions, say it's an LPR in PA, no problem. We have alienage jurisdiction, and the except clause does not divest jurisdiction. Equally so, say this defendant is not an LPR, but is domiciled in Florida. Also not a problem, because both conditions have to be met. It's got to be a foreigner who is an LPR who's domiciled in the same state. Now let's briefly look at A3. A3 is a special case. A3 allows aliens to sue aliens. Allows aliens to sue aliens under the diversity statute, but only if we already have citizens of different states. So in a sense, it's kind of like combining A1 and A2. Not exactly, but if you think of it that way, that'll give you the kind of in conceptually. So say, for instance, you have Florida versus New York, citizens of state, domiciled in the state, so I'm saying they're citizens of Florida and New York, and the other parties are Germany and France. Okay, that would be okay under A3. The threshold condition is you have to have citizens of different states, so it's very close to A1, all right? And then when that threshold is met, then you can add foreigners as additional parties. So look at how this fleshes out. This is okay under A1, citizens of different states. This is under A2, it's a citizen of a state versus a foreigner. This is also okay for the same reason. Here we have a foreigner versus a citizen of a state, A2. Now look at this. This is a foreigner versus a foreigner, right? So A1 doesn't count because it's not citizens of different states. A2 doesn't count because it's not a citizen of a state versus a foreigner. This is where A3 kicks in. Why? Because you met the threshold condition. You have a lawsuit between citizens of different states, and that allows, under A3, the joining of additional parties who are foreigners. But be very careful about this. The threshold condition is you must have citizens of different states. So if it's Florida and Germany versus France, that's not going to work. Florida versus France is okay, A2, that's alienage. But Germany versus France isn't going to work at all. Why?
No.
You don't have a dispute between citizens of different states. Put differently, the threshold condition here in blue is not satisfied, and since the threshold isn't met, the whole thing falls apart. So you can't have this second claim between Germany and France. Let's briefly talk about some special circumstances under the diversity statute. First, corporations. Corporations can be citizens in multiple places. They are citizens in every state and foreign state where they're incorporated. That's usually just going to be one, but it could be more than one. And of the state or foreign state, that's the PPOB. All right? That means only one PPOB, and then there could be one or more states of incorporation. Okay? And this is an easy one. How do we normally measure PPOB for purposes of diversity? That would be the Hertz case. That looks typically to the nerve center, the headquarters, where the decisions are made. Another special case, well, before I move into that, let's finish up with corporations. Now keep in mind that C1 is about corporations. So C1 would be things like a corporation. It might be a PC, professional corporation, but it's not going to be a partnership. It's not going to be a limited partnership. It's not going to be LLC. LLC stands for what?
Limited liability company.
Very good. It's not going to be an LLP, limited liability partnership. There's also things like LLLPs, believe it or not. These, you measure the citizenship by each and every owner. So, for example, if you have citizen of PA versus a general partnership, and that general partnership in turn consists of X, who's a citizen of Florida, and the other partner is Y, who's a citizen of PA. Guess what? This general partnership is a citizen of both Florida and PA, and therefore complete diversity is lacking because you've got PA on both sides. The same is also true of unincorporated associations such as a union, like the Teamsters. You look to the citizenship of each and every member of the union. All right, moving on. Also remember legal representatives of estates. All right, so say for example, excuse me, you have a citizen of Florida versus a citizen of Pennsylvania, and the citizen of Florida dies and is represented by executor who's a citizen of Pennsylvania. So the executor, the Pennsylvania executor, is representing the estate of the Florida decedent in a suit against the defendant, say for like a suit in tort for wrongful death. Okay? Well, you think, oh my goodness, PA versus PA. But no. In a representative suit like an executor or administrator, the executor or administrator takes on the citizenship of the decedent. You might get a different result if the executor was suing in two capacities, right? Claim 1 is on behalf of the estate, and Claim 2 is on behalf of this person, him or herself. Imagine a spouse dies. Other spouse is the executor. Happens very often, right? and then sues the other driver from a car wreck. Well, the spouse who's the executor might say, hey, I'm suing on behalf of the estate, in which case I'm a citizen of Florida, but I'm also suing for my own emotional damages or loss of consortium or whatever, or maybe my own personal injuries, right? To the extent that this person is suing on their own behalf and on behalf of the estate, then this person is a citizen of what? PA or Florida? PA. Very good. All right, let me look at my notes real quick. Court of partners, very good. Very good. Very good. All right, now let's move on to amount and controversy. Oh, let me give you a quick hint real quick before we move on to that. When you have an essay, or even in a multiple choice, you have to go party by party, claim by claim. All right, if you have an SMJ fact pattern that involves diversity, all right, make sure that you analyze the citizenship of each and every one of the parties, right? And then figure out which bases might or might not be satisfied. You know, A1, A2, A3. I don't test on A4, but A1, A2, and A3, I've tested on those in the past, all right? So organize it that way. Make sure you analyze each and every person separately. Let's move on to amount and controversy. And of course, we have a couple things. First is the St. Paul Mercury test. And I had a question on the midterm about that, and a lot of people had difficulty with it. Keep in mind that the court doesn't have to be certain the amount in controversy is met. It's just that the court needs to know whether or not it won't. Put differently, here's the language from the actual St. Paul Mercury case. Part of it's reproduced in the Moz case, right? Good faith controls unless we have legal certainty the claim is really for less than the jurisdictional amount. Okay? It doesn't have to be certain the P will get over 75K. A lot of people get that rule wrong in essays. They think, oh, we've got to be certain we'll be over 75K. Instead, is the court won't dismiss unless the court is certain the PA cannot get more than 75K. Put differently, this is akin to possibility pleading. It's not quite the same thing, but what you should be asking yourself, is it possible for a reasonable juror to award over 75K? If it is possible for a reasonable jury to give over 75K, then the amount is okay. It pleaded in good faith, all right? Even if the court is doubtful, even if the court is uncertain as to whether the plaintiff could get over 75K, that's okay, as long as a reasonable jury could find over 75K. You see, we don't have to be certain it's over 75K. We only got a real problem if we're certain it won't be. All right? This is something, again, that I'd be very happy to post to the website. Would you like that posted?
Yes.
Okay. So, you know, when I get the videos, I'll post all that stuff. And when I get a chance to sit down, I'll post all that stuff. Hopefully it'll be tonight or tomorrow night. Sound good?
Yes.
Alrighty. One last thing is aggregation. Keep in mind that aggregation is something else that comes into play with amount and controversy. Plaintiff can aggregate together unrelated damages. So say you sue the defendant for $50,000 for running over your foot, and then $50,000 for a completely unrelated claim for, I don't know, a fraud, all right? One is a foot injury, another one is unrelated fraud. Well, these can be aggregated together so that the amount in controversy is satisfied, all right? Now compare that to P versus D, and you have two different theories for the same relief. Say you have 50K for negligence and 50K for an intentional tort. And they both are due to the same thing, right? Say the defendant sees you and runs over your foot, causing $50,000 worth of damages to your foot. Well, count one is for negligence. You weren't paying attention. Count two is, how dare you did it on purpose. But it's the same $50,000 expressed via two different legal theories. The amount of controversy is not met. It's just $50,000. Also keep in mind that you can only aggregate against the same defendant, like in the original hypo. What you can't do is aggregate against separate defendants. So say you're seeking 50K over D1 and 50K over D2, you can't aggregate those amounts, even if they're from separate damages. So say there's a car wreck and D1 runs over your foot and D2 destroys your lawn, okay? Two cars run into you. One runs into your foot, the other one at the same time goes into your yard, destroys your yard, okay? That doesn't satisfy it. Aggregation is only when the lumped together but separate amounts are asserted against one defendant. And it goes the same way again. P1, P2 against defendant. Suppose there's an insurance coverage claim, all right? And P1 is seeking $50,000 for the plaintiff's damages, and then P2 is seeking a separate $50K. Again, you can't aggregate that. Those are separate parties. You can't aggregate separate parties' damages, and you can't aggregate one party's damage against separate defendants, okay? It's got to be that one-on-one kind of thing. There's an exception that's in the problem set that I'm not going to get to that talks about indivisible injury. If you're interested, go look at the problem set. I'm not going to get further into that now. All right, now that's diversity jurisdiction. Now, let me look at my notes real quick. I think I've hit everything I want to. Now let's go into federal question jurisdiction. Now going back to Article 3. At the beginning here, all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. That's the constitutional scope of Article 3, federal question jurisdiction. And under the Osborne case, all that's required is that there be a federal ingredient in the original cause of action. That federal ingredient could be the cause of action in the complaint. It could be a counterclaim by the defendant. It could be the plaintiff asserting a federal defense, anticipated federal defense in the plaintiff's complaint. It could even be a state law claim that contains a stated federal issue. As long as there's a federal ingredient in that original action somewhere, then the Constitution is satisfied. Now for the statute, it's a good bit more complicated. The statute's language is very similar to the language in Article 3, but 1331 has never been read as broadly as Article 3. For 1331, it's not enough to have a federal ingredient in the case. Instead, what we got to do, and I'm going to go straight to it, analyzing federal question. The first step is Article 3. The second step is 1331. All right, we already talked about the first step. Is there a federal ingredient somewhere in the case? If so, Article 3 is satisfied. The second step is more complicated. It's got a filtering step and then an analysis step. And then the analysis step has two alternatives. All right? 1331. First, the well-pleaded complaint rule. This is not a standard, but a rule. It's a rule because it's capable of fairly clear application. It tells you where to look for a federal question. Do you look in the complaint or the answer? Do you look in the complaint? You're looking at the plaintiff's complaint. Do you look at the plaintiff's cause of action, or do you look at anticipated federal defenses? Plaintiff's cause of action. You don't look at counterclaims. You don't look at anticipated defenses. You just look at the cause of action in the plaintiff's complaint. The well-pleaded complaint rule doesn't tell you if there's a federal question. It just tells you where to look for one. It's only in that second step. You ask if there's a federal question. So now we're looking at the plaintiff's cause of action. We've got two alternatives. One's a rule. The other's a standard. The rule, alternative number one, is the Holmes creation test, also known as the American well works test, all right? Or even the origination test. What it does is it asks, here's the cause of action, who created it? What lawmaker created this cause of action? Now, if you're dealing with a common law cause of action, like a tort claim or a contract claim, or something under a common law property law, or under a state statute, right? Well, that was created by state lawmakers, all right? Under the Holmes creation test, that case, that claim would not arise under federal law because it was not created by federal lawmakers, all right? The Holmes test is a rule. Again, fairly easy to apply. If you have a copyright cause of action, who created that? State government or the federal government? Federal. A 1983 claim, state or federal?
Federal.
Federal. 1983 claim is a congressional statute. That's come up in some of our cases, civil rights claim under section 1983. A claim for IIED, state or federal?
State.
State. All right, so the Holmes creation test, pretty easy to analyze. What's a real bear is alternative number 2, the Grable gun test. This is not a rule, it's a standard. So first, you need to recognize the scenario where the Grable gun test is applicable. That's when the plaintiff's cause of action was created by state law but contains a federal ingredient. Okay? Think of it as, I don't know, a bowl of pudding. Okay? A bowl of pudding that contains a federal piece of fruit. Okay? Now what that means is the Holmes creation test would say that the claim arises under state law. All right, say for example you have a state negligence claim. Under the Holmes test, state law creates negligence and there'd be no federal question. But under Grable gun, we also sometimes allow 1331 jurisdiction where the cause of action was created by state law but contains a federal ingredient. So you have that state law negligence jello that's got a piece of federal pineapple inside of it, okay? And the question is whether or not the federal pineapple is so big or so substantial or so important that it's going to be enough to trigger 1331 statutory federal question jurisdiction. And here the court uses a standard. Here it is up there, right out of the case. Does the state law claim necessarily raise the state and federal issue actually disputed substantially? The federal court may entertain without disturbing any congressionally approved balance of federal and state judicial responsibilities. Got it? All right. That means federal jurisdiction over that state law claim. And here, that's the cause of action in the plaintiff's complaint, right? All these have to be satisfied. The federal issue, first of all, is there a federal issue? That federal pineapple, right? It's necessarily raised, actually disputed, substantial, and capable of resolution in federal court without disputing Congress's choices regarding the distribution of authority between state and federal courts. All right. Well, necessarily and actually are going to usually be easily satisfied, because there it's actually stated in the complaint. So you look to what the complaint says, and is this something the parties are actually disputing or fighting over? Think of, for example, in the gun case. Remember in gun, they were fighting over that federal patent defense? It was an attorney malpractice case, right? But in that case, the only really disputed issue was whether or not that federal patent defense should have been used in an earlier litigation. All right? These are easy to satisfy. These are the arguable ones. All right? Let's do them out of order. Number 4 looks to the dockets of state and federal courts. If the court would allow jurisdiction under the facts at hand, would that lead to the floodgates opening in federal court for state law claims that contain some federal pineapple? All right? This is concerned about floodgates. Factor number 3 is about substantiality. And here substantial does not mean important to the parties, because usually these issues are going to be important to the parties. It means important to the federal system as a whole. So in Grable, the important issue to the federal system was notice regarding tax matters. All right? Well, that's important to the federal government for obvious reasons. In the gun case, however, the patent issue was not important to the federal system as a whole for a bunch of reasons. As the court said, there'd be no res judicata effect, there'd be no precedential effect. The only people that would be affected were the parties. So I think that if you get a fact pattern involving the federal pineapple, right, be sure to think about arguments and counter-arguments that might be raised by either party. The fact pattern may be very indeterminate. So, put on those empathy hats where you empathize with the plaintiff. Here's what plaintiff says, here's what defendant says, what's the better argument? and bring up arguments so long as they wouldn't piss off Justice Scalia. All right. A couple other things. There's other statutes as well. There's the patent, copyright, trademark, plant variety patent statute, which provides original jurisdiction in federal court for any act of Congress relating to patents, plant variety, copyrights, and trademarks, and then provides exclusive jurisdiction to 3 of these: patents, plant variety, and copyrights. That means that in federal court, we can hear any of these causes of action. And it further means that state courts can't hear 3 of those 4 claims at all. So claims for patents, plant variety, or copyrights. All right. And there's a, there's a removal statute, which we'll get to in a little bit. All right, I think that's it for federal question. Give me a second, and I'm going to move on now to removal. All right, removal. First, let's make the distinction between removal and remand and transfer. Removal is when the case is taken from state court to federal court. Normally, that's only done by the defendant, or the defendants, I should say, and not by the court. When the case is sent back down to the state court, that's called remand. Neither one of these are called transfer. We talk about transfer, we're now into the statutes, 1404 and 1406, for change of venue. So if you're talking about removal, don't talk about transfer unless you mean to be talking about change of venue under 1404 or 1406. A couple other things about removal. When you remove the entire case. You don't remove a claim, you remove the entire case. Another thing about removal. All defendants who have been properly served must consent to the removal. Here's yet another thing about removal. Normally, removal has to be done within 30 days of service. All right? Well, there's some exceptions to that. For example, under 1446, there's that statute we talked about with the rule, the exception, and the exception to the exception. Okay? What if a case is not initially removable, right? Say, for example, it's Florida versus Florida and Pennsylvania. It's negligence, and the defendant is seeking $100,000 against each, and it's filed in state court. Well, obviously the case is not removable yet because diversity is not complete. But suppose eventually the first defendant is dismissed. Now the case becomes removable for the first time. Well, even though the normal statute of limitations to remove is 30 days, here the case has now become removable for the first time. So now we get a 30-day time to remove. However, what if the only basis for removal is here diversity of citizenship under 1332? Well, then that means, let me find the subsection. Here's under C1. A case can't be removed on the basis of diversity if it's being removed more than 1 year after the commencement of that lawsuit in state court. So say this person here, Florida, is dismissed from the state law claim 10 months after the original lawsuit started. Well, then the remaining case can be removed. But what if this person was dismissed 18 months after the lawsuit commenced in state court? Then it's too late to remove because of that 1-year statute of limitations. Now there's a further qualification on that 1-year statute of limitations, which goes to the reason that this person was kept in and later dismissed. Is it good faith or bad faith? If this person was dismissed in good faith, then the statute of limitations will prevent removal if that dismissal is more than a year after commencement of the state law action. On the other hand, this person was brought into the suit and kept in the suit in bad faith, say to prevent removal, right? Then the 1-year statute of limitations would not apply. And that kind of makes sense, right? Suppose this person was brought in just as a way to defeat removal, right? And then, boo, a year's up, and now we're going to dismiss this case, and we're like, boo-hoo, we never wanted to sue this person in the first place. Well, the way the statute will work is that even though you can't remove this case more than a year after originally filing, here this person was kept in for the sole purpose, in bad faith, of preventing removal, and now the one-year statute of limitations is not going to apply. Now, in your review, go back to the statute. Think about, look at your notes, see how we drew lines from the different parts of the statutes to each other. I'm not going to go over that in detail now because that would take like 20, 30 minutes, and today we just don't have that kind of time. All right, let's see. Other things regarding removal. For removal to be appropriate, there's got to be original jurisdiction. What that means is you can't remove a case from state court to federal court unless the federal court would have original subject matter jurisdiction. That could be diversity, that could be federal question, it can be more specialized kinds like patent or trademark and so on and so forth. There is a big qualification on removal. That's the forum defendant rule, which means that diversity-only cases are harder to remove than they are to put in federal court. So say, for example, you have a citizen of Pennsylvania sue a citizen of Florida and a citizen of Alaska, okay? And say the lawsuit is filed in Pennsylvania, all right? And the amount in controversy is met, no problem there. Well, could this lawsuit be filed originally in federal court? Is the amount of controversy met? Are the parties completely diverse? This could be filed originally in federal court. Say it's filed in Pennsylvania state court. Can it be removed? Yes. What if instead it's filed in Florida state court here in Dade County? Can the case be removed? No. And the reason is the forum defendant rule. All right? The forum defendant rule prevents removal, that's 1441b2, when the sole basis for jurisdiction would be diversity, and at least one of the defendants is a citizen of that state. The rationale being less need for federal forum because it's a diversity case, and less chance of bias because at least one of the defendants is a citizen of the state. So you just told me this case can't be removed from state court to federal court. What if it was originally filed in federal court? Could this have originally been filed in federal court? Yeah. You see, this case can be filed in federal court, but it just can't be removed from state court to federal court. Interesting little twist. Let's see what else. Just I think two or three more things on removal, and then we move on. The first one is the timing of remand under 1447. Remember how I said removal is normally within 30 days of service on the defendant, right? All right, of the last served defendant, I should say. Well, a motion to remand normally has to be within 30 days after the filing of the notice of removal. All right? 30 days. However, there's an important exception to that rule. So you have to ask yourself, what is the reason for the motion to remand back down to the state court? Is it because of a defect in removal, or is it because of a defect in subject matter jurisdiction? If the defect is subject matter jurisdiction, then the case can be remanded at any time before final judgment. All right? To sum up, if the reason for remand is lack of SMJ, then remand can be far more than 30 days after removal. It can be any time before final judgment. But if the basis for remand is a procedural defect in the removal, then we have a 30-day limitation. All right, let's see what else. There's another couple interesting things about removal, and then we move on. The first is this bizarre section, 1441C. That applies when you have, and this kind of rarely happens, say you have a federal question and an unrelated state law claim and diversity is lacking. So for example, say you have, oh, I'm running out of space. Let's see if I can move this. Okay, here, we'll just do it over here. Say you have P versus D, now let's make it Florida versus Florida, and there's two counts. One is for 1983 civil rights violation seeking $1, okay? And here we have an unrelated breach of contract seeking $1. Well, the 1983 copyright, the 1983 civil rights, that's a federal question, okay? But here we have an unrelated state cause of action for breach of contract seeking $1. Now, think about it. Could this entire lawsuit be filed in federal court?
No.
Could it? Could that by itself be filed in federal court?
Yes.
Florida versus Florida for $1 for a federal question? Yeah. How about this unrelated breach of contract for $1? Florida versus Florida. Could that be in federal court?
No.
It can't. But suppose that's filed in state court. Well, C1 says if civil action includes a claim arising under the laws of the United States within 1331, and this first claim here is a 1331 federal question. And another claim not within original or supplemental jurisdiction, okay, then the entire action can be removed, all right? And then what you do upon removal is you sever the action from the action, the claims that shouldn't be there, and remand them back down. So how this works is you would remove this entire case, you would sever out this claim, you would keep the federal question claim, and you would send back down this separate claim as a separate civil action down to the state court. You remove the whole thing, you take this out, you sever it, and you send just this back down. That's how 1441C works. Kind of bizarre. One last thing on removal is the removal provision for patent, copyright, and plant variety protection actions. This allows the removal of patents, plant variety, or copyrights, and there's some interesting things about it. First, it can be removed by any party. Normally, removal is just by defendants. Here, the removal can be by any party, plaintiff or defendant. And also, the patent or plant variety claim or the copyright claim doesn't have to be in the complaint. It could be in a counterclaim as well. In any party, a civil action in which any party asserts a claim for relief arising under one of these federal statutes. That means if the patent claim is only in a counterclaim, you remove the entire case, okay? Now, what you do is, this part here under D is very similar to 1441C. Remember I said under 1441C, you remove the entire case and you send back down the claims that shouldn't be in federal court? Well, that's the same thing here. Civil action is removed solely under this section. The district court shall remand all claims that are neither a basis for removal under subsection A, nor within original or supplemental jurisdiction of the district courts. Okay, and so on and so forth. So, you remove the whole case, you keep the patent or the copyright or plant variety protection, and if there are additional claims that are lacking original or supplemental jurisdiction, you send them back down. Okay, so that's removal. Now let's move on to notice for a few minutes, and I'm going to stop the video.